Great. Welcome, everyone, to today's webinar, the new app webinar, Trauma Informed Care, Part 2, the nuts and bolts of immigration story writing intervention. It's a pleasure to have so many people joining us. This is a joint project being brought to you by NewApp and the American University College of Law, Legal Momentum, and Calcasa. I'm glad to have all of you joining us today. Please note this project was supported by grant number 2011 TAAK-K002, awarded by the Office of Violence Against Women, U.S. Department of Justice. The opinions, findings, conclusions, and recommendations expressed in this program are those of the authors and do not necessarily reflect the official views of the Department of Justice Office on Violence Against Women. I do want to talk briefly about how to use the technology today. In order to use this technology, that we would have, that you can do many things. One of the things you can do is raise your hand. And the way you raise your hand is if you look on the picture, of my picture on the left, and on the top hand, you'll see a hand that says my status. I sort of circled where it looks like. Go ahead and everyone raise their hand. I only have one person raising their hand as of now. So let's get everyone to please raise their hand. Oh, good. I'm seeing the numbers of people going here. I'm actually going to move the text chat to the other side for everyone so it'll be easier to read. Wonderful. Thank you for all joining us. That's a great way. That's how you raise. I'll lower your hands now, but that's the way we can do the information. We do have PowerPoint slides for today's web conference. They will be available on the new app web conference. And if someone can post the link where the slides are available, I would appreciate it. It's probably going to be Christina who's going to, or Rocio will be posting those the slides. You can get those and the materials now in the text chat, and also in the follow-up email we'll say something. And we'll be asking a few polling questions later. You're on the phone right now, or you can call in for information. We will be taking questions through the text chat. To do text chat, you just write a message here and click here. If you want to send a private message, there's a private tab, and you can click people and ask private questions. But most of the questions that we have coming through are from are going to be on the text chat. So thank you, Rocio. Just put the URL to be able to get the information on all of where the materials, including copies of the slides for today. I do want to introduce the speakers that we have today, and I'm really pleased to be able to have with us Leslie Orloff, who's the director of the National Immigrant Women's Advocacy Project, NewApp from American University, Washington College of Law. Hi, Leslie.
Hi. Welcome, everybody.
We also have Mary Ann Dutton, and she's from the Georgetown University Medical Center on Trauma in the Community. Hi, Mercedes. Hi, Mary Ann.
Hello. Good afternoon.
Thank you. I was jumping ahead to Mercedes Lordu, and she is the co-director of Vita Legal Assistance. How are you doing, Mercedes, today?
I'm very well, thank you.
Great. Well, glad to have you. And we're also joined by Edna Yang, and she is the general counsel with American Gateways. Hi, Edna.
Hi, David. Hi, everyone.
Great. And we're asking people in the audience just to get a sense of where you're from. So go ahead and write down the name of the names of the organizations that you're with, and we'll just get a sense of who's in here. And so we've got to see who's joining us, and we've got people already starting to write that in. So just go ahead in the text chat, write down what's the name of the organizations and type of organizations and where you're from, and we can see a wide variety of organizations. It's going to scream by fast on the screen, but we've got people from a wide variety of organizations that you can see who are providing services.
Probation officers.
Probation officers. I see a lot of people from advocacy organizations. I see a lot of people from DHS, from their states. I see Catholic Charities, legal aid, pro bono services. I see more legal aid, legal services, a therapist, victim advocates, Asian support services in Austin. So, Leslie, I'm seeing a pretty good variety of people that are joining us.
Wonderful.
Great. So let's ask a question of the audience to get a little bit of a sense of what type of organization you're in. So what I'm going to do is give on the left-hand side, there's a little box, and click which one best describes you. Are you a lawyer? Are you a domestic violence or sexual assault victim advocate? Are you a mental health or a health professional? Are you other? which is D. And so go ahead, and I see that there's still 100 of you, 90 of you, or 86 of you who have not voted yet. But Leslie, let me go share the results and see what we have who we have in our audience. And what we have is about 44% are domestic violence or sexual science advocates. We have another 27% that are lawyers, and we have about 18% other and 8% mental health or health professionals. And if you're an other, go ahead and write that in the text chat so we get a sense. So let's say about half of our audience are domestic violence or sexual assault victim advocates, and another quarter are attorneys.
Great. And if you could, those of you that are the other, type in what you are. That would be helpful for us in terms of understanding who's in the audience.
Great.
David, do I take over now?
No, well, I think actually I was just putting your name here. I think you were going to read the,
yes.
You were going to go over the objectives, right, Leslie, or was I?
I am. The learning objectives for this webinar training are to help you all improve the process of developing the victim's story in a VAWA T or U visa case by using a brand new tool that we're unveiling today, actually. Those of you that were on Trauma Webinar 1 saw a version of this, but we're actually introducing the final version with this webinar today, and it's a structured questionnaire for immigration cases, and structured interview questionnaire for immigration cases. And that we're going to talk about how to use the immigration story writing intervention technique and approach that both helps clients, new clients who are coming in and just starting with these cases, ideally reveal more information sooner so it's easier to develop their story in their VAWA T or U immigration case. And it'll also help with the existing clients that have had difficulty telling their stories up until this point. And then Mercedes will be talking in detail about those two different ways to use the survey instrument that we're going to be talking about. We'll also be talking about responding to survivors in crisis and who are dealing with kind of the emotional responses they have in a trauma-sensitive way to getting the information, because this is an area of the law where victims have to write their stories, and that can be very traumatic. And then finally, we're going to be talking more about and giving you some tools that are related to helping identify the patterns of coercive control that exist in immigration cases that are useful in documenting and that documenting those can be very useful in immigration cases, and it plays out in a variety of ways, and we'll be talking about those throughout the webinar. Okay. So just to review, this is the link to the webinar materials. If you're on a computer, feel free to open that up in a parallel screen or whatever. You can see the materials as we're talking about them. You'll find there is a copy of the PowerPoint. You will get the structured interview tool. You'll have a link to last time we did the part 1 of this, we also distributed a tool for advocates that was designed to help, shuffling my papers here, designed to help advocates who are working with survivors develop the story as well and prepare for working with immigration lawyers or doing the case on their own. And then we also have a tool that we're having as part of this webinar, which is battering and extreme cruelty and coercive control, and showing you how
audio.
Can you have everybody mute, please? David?
Okay,
sure, I'll take care of that. Just one second.
Chad, can you mute everybody and then we'll come back on?
Yeah, sure will. Just 1 second.
Hold 1 second.
All guests have been muted. You can unmute your line by pressing *6.
Okay, thanks. We're now back in the web conference. Leslie?
Unmuted it. Oh.
If the speakers could please unmute themselves, but only the speakers, please. And just go ahead and check in to make sure that we can hear you.
So, Leslie, are you on the line now?
This is Mercedes.
I'm Mercedes.
This is Marianne.
Hi, Marianne.
This is Edna.
Hey, Edna.
Leslie, you'll have to press *6 so we can hear you, please.
Leslie, still don't hear you.
Hello?
Hello,
Hi,
Leslie.
Leslie.
You have me?
Yes.
Yes, we do.
I'm sorry. I think I was hitting #6.
They're very similar. Go ahead. Please continue. Thank you.
So, we have this battering or extreme cruelty and coercive control tool that we think would be very useful. It draws on civil protection order or family law cases, the history of case law in this area, and integrates it with some of the groundbreaking research that Marianne Dutton has done on coercive control, and will help you identify power and document patterns of coercive control that can constitute extreme cruelty involved with self-petitioning cases, but that can also help support your claims of substantial harm in U visa cases, and also assist in trafficking victim cases as well. And then an additional tool that we don't quite have ready yet, but should be up on the web by April 15th, is we developed a video of working with Marianne that will allow you to see how to do trauma-informed work with clients in crisis. And essentially, it'll be a 2-hour video in segments that you can take, and we covered things like how do you deal with how do you work with clients effectively in a trauma-informed way when they're dealing with intersecting traumas in their lives? How do you work with a victim who's overwhelmed, shaking, crying, really upset, and how do you help calm her down and work with her around the affidavit? How do you work with a client who's been shut down, who's just shut down and having difficulty talking about the abuse, somebody who's suicidal, somebody who's depressed? And then how do you identify patterns of coercive control in the cases that you're working with? And this is going to be a YouTube video published by American University at NEWAP, the National Immigrant Women's Advocacy Project at American University, that'll be available as a supplemental tool to this webinar, and it'll be, as I said, up before April 15th. So check back in about a month. Those of you that are on the call will be sending you an announcement and a link to the video when it becomes available. And if any of you on the call, we are looking for a video editor. We have everything filmed and shot, and we need an editor to pull it together. So if anybody knows somebody who would be interested in doing that pro bono, please contact us as soon as possible. Anyway, David.
Yes, great. So with that, what we're going to do is move to a question for the audience, and want to know how many people did attend the part 1 of this series. So go ahead, on the left-hand side, just go ahead and write down if you have attended the part 1 that we did. This was in November, right, Leslie?
I believe so, yes.
So let's see, and I'm actually sharing live results, so people are seeing that we're it's about 43%. Not everyone has voted, but 43% have attended, but 55% have not. So there is a recording available, and I know that Rocio has put that link to that into the next chat. So I do encourage people to get that for other background information.
And let me just say, this is Leslie again, that we see these as a package, so that there's if you're working with people that, if you know people that attended the first and didn't attend this webinar, that the 2 webinars, the materials and the video, are a package that will all be available from the website, so that we encourage you, if you're joining us for the first time on this webinar, to also listen to the other ones. That material, we're not repeating the same material here. These are designed to be a supplement to each other.
Great. Great, Leslie. So,
to fully understand and participate in this webinar if you didn't participate in the first one.
So and then let's get a sense. Why don't you get a sense of I'm asking a different question. I'm going to shift this to becoming an A, B, C, D. And What experience have you had in developing a VAWA self-petition, a U visa, or a T visa affidavit? And so A is you've had no experience, B, a VAWA self-petition only, C, a U visa only, or D is for those who are more experienced, who have done those. And go ahead and fill this in on the left, and I think we're already seeing this live, Leslie, people sharing. So we have half of our audience have no experience. So we have people there. Another 1/3 of our audience is very experienced with VAWA, U visas, or T visa story development. And then a few others have done VAWA self-petition only or U visa only. So Leslie, we have a lot of people that this is going to be new to them.
Okay, great. That actually is very exciting because part of the reason that we are doing this series is that we believe that both advocates and lawyers can play a very big role, and therapists and other service providers can play a big role in helping immigrant crime victims develop their stories for VAWA and U visa cases. And those stories are really a very, very important part of, or a key part of the immigration case. And it's a unique opportunity as well to not only, that one of the things that we're excited about, and the team of faculty that are working on this, or that are presenting this webinar together, have worked hard on really thinking about what kind of an opportunity it is, not only to develop a successful immigration case, but to help the client heal at the same time. Mm-hmm. And so the affidavit is the most important piece of evidence submitted. It is what the Department of Homeland Security, it's the testimony that they hear, so it's very important that the story not sound like it's written by a lawyer, and that it really be in the survivor's voice. And so it's less affidavit than an actual story of her experience, and that the process of retelling this story in a way that it can be conveyed to the Department of Homeland Security in these cases can be very traumatic for survivors. And so we wanted to devise a method and test a method that you'll hear the results of today that would allow us to develop an approach that would result in more effective and more complete immigration cases that are going to be more successful more quickly, and improve outcomes in terms of the survivor's healing at the same time. The immigration story, in writing it, is a process in which the advocate or the attorney, essentially the way that we think about this is it shouldn't be the advocate or attorney listening to the story and writing it down necessarily. Where the victim can write, it would be better to essentially support the victim in the process of telling her own story and capturing that trauma history is what helps facilitate victims in healing. And Marianne, can you tell us a little bit as background about what research tells us and why telling the story is helpful in healing from trauma?
Sure. There are a number of studies that have been done that have looked at the narrative, people telling their own narrative or writing their own narrative, which is essentially telling their trauma story in various structured ways. It's important that in the telling that there is a structure and there's safety so that the individual doesn't get flooded. But the research tells us that exposure to one's own story and repeated exposure helps the survivor assimilate, if you will, the emotion related to the story. And over time, with repeated exposure, the story becomes a story but without the overwhelming, flooding experience that can come along with a very traumatic story.
So, Marianne, would you say it's true that actually this process, which is very painful for clients to go through, that we're proposing of kind of telling and retelling and writing down and rereading the story, is something that us as advocates and lawyers shouldn't necessarily be afraid of because we're harming the victim, but by actually doing it correctly and supporting her through the process, we're helping her?
Potentially, the whole point of this is that it can potentially become a very healing experience. That, as we talked in part 1 of this webinar, witnessing the story, having someone listen in a very active, supportive, non-judgmental way, just by itself can be hugely healing. And because the survivor needs to tell the story for the purposes of developing this legal document anyway, the goal here is to create a process that does no harm, that doesn't just re-traumatize her or him, but rather creates a process whereby healing can actually occur. It doesn't mean that this is the entirety of all the healing she will ever need, but rather that it's a process that can be a healing one instead of one that is often avoided, re-traumatizing, and ends up with the survivor feeling in some ways even worse for having dug all this up. The intent, the goal, is to have it be healing instead of that.
David, next.
Okay, back to you, Leslie.
Great. So we developed the structured interview questionnaire for immigration, which includes questions in multiple examples and samples used by, we looked at examples used by immigration experts around the country. We looked at the standardized research measures that have been developed over and tested over the years. And we created a tools for agencies to use, both the advocates tool and the questionnaire that will, and then we actually had Mercedes at VITA and Edna at American Gateways test these with clients and provide feedback to Marianne and the team, and then we revised and finalized the tool, and submitted it to OVW for approval, and it's now part of the webinar material. So this is the research team. It's myself, Edna Yang and Mercedes, the immigration attorneys. Rocio Molina has been part of this. She's doing the chat for us. She's with New App as well. And Marianne Dutton is the trauma expert who's worked with us on this. And so essentially here, the way to think about what we're doing, and we talk about this a lot more in the first webinar, but is to create, the first time you meet with a client, it's around these kinds of cases, or when you start working on her story, the first time she's telling you the whole story, the goal is to allow it to come out in an uninterrupted, unedited way, where we as advocates or lawyers are witnessing, listening without judgment, and creating the space for her to tell it. And so it is not and that it is only at the second interview, the second part of that process, where you're doing the follow-up interview, that you begin to use the structured questionnaire to really do a structured interview and fill in the gaps and get more details of the story. Some people might find it useful during the first part, where you're listening to the client tell the story, to make notes on the structured interview questionnaire, so that you, when you go back and use the questionnaire, can work from the questionnaire and the notes you took at the time. But it's really designed that part 1 is to have the story come out, part 2 is the follow-up interview. And then what happens is that you, as the lawyer or the advocate helping the victim on her VAWA or U visa case, will then edit the story together into a cohesive whole. And then at the end, the last part is the survivor reads the story back to you, instead of you reading the story to her or having her read the story not out loud before she signs it and it's submitted. And that last part is very important to this whole process in terms of the healing and how it works. And so, as I said, a little bit more on each of these. Part 1, you're creating a safe environment, allowing space for the person to be silent, really creative a place where they can talk and tell their story themselves. Part 2, you will then go back and use the questionnaire to obtain detailed information and the idea there is to use the tool to help you identify additional incidents of abuse, additional background. Ask some detail about things that were previously discussed in the first interview. But the questionnaire format is designed so that it will trigger her telling you about things that she may not have told you about before. And so, Marianne, and as part of the structured interview, we have used tools that we've incorporated into the tool that we've given you, the interview tool we've given you, information that has been proven successful in research that people are willing or able to respond to and provide information about additional abuse history they've suffered. Marianne, do you want to discuss these?
Sure. So let me just reiterate that this part of the tool comes after the survivor has had a chance to tell her story. So it's very important, I think, to reiterate that, because there's nothing more frustrating than trying to tell your story and having someone sort of interrupt with these very specific repeated questions that can feel very confining. However, after she's had an opportunity to tell her story openly and freely, then moving into another phase where one would, by way of providing an explanation about why these questionnaires and why these structured questions would essentially say that one wants to really make sure that we don't miss anything, that I totally understand and have a full picture, something along that line. And although one might not say this, what I'm about to say, it's also true that trauma, which is what we're talking about, these are all trauma stories, essentially, is such that trauma can play tricks with memory. That is, trauma stories don't come out in a straight line. They don't necessarily come out all in one package, coherently, in a factual, line-by-line, point-by-point basis. And so this becomes another tool by which one can actually get a more complete story. So although these are structured, these often can lead to information that would then feed back into a more open narrative about, oh, I forgot to tell you about that. Let me tell you that part of the story now. So that said, what I'll do now is just go through these pieces of the structured interview, which largely many of you may recognize some of these. They're well tried. Most of them are well tried and appear in the literature a lot. They're commonly used in both clinical and research contexts. So the first set of them really are tools all designed to get at and get more information about multiple components of the domestic violence experience itself. So the conflict tactics scale, the revised version, although it's under a fair amount of criticism for various reasons, is a fairly good tool to assess just what are the actual physical and psychological, and they have, actually there's a whole range of types of abuse, but physical and sexual and even verbal acts or behaviors that have occurred in this person's experience. So it's a fairly comprehensive list, and although it's not everything, it can prompt a recall of events and acts that have occurred that might not have been spontaneously reported. The second, Psychological Maltreatment of Women inventory by Rich Tolman, is an inventory focused exclusively on psychological abuse, both verbal abuse and controlling isolation types of abuse. The third scale is an interpersonal, intimate partner violence coercive control. It's essentially a suite of measures, meaning it's just multiple measures. But embedded in there is the core measure of coercive control acts, that is, what are coercive control behaviors that might have occurred. Using the suite as a whole set of measures, one can get at what are the kinds of demands that have been issued, that is, the kinds of things around which control has been exercised, how does the person who's doing the controlling maintain that control? That is, what are the tools they use? So it has a number of different components to that measure. The fourth measure, the intimate partner violence threat appraisal measure, gets at the survivor's subjective appraisal of how much threat there currently exists as of now. Sort of going forward, what's the likelihood, the perceived likelihood that certain events would occur. So it recognizes the fact that although we're talking largely about traumatic events and abusive events that have occurred up to this point, it recognizes that the survivor may not be entirely out of danger at the moment, and so one can get an assessment of how much current threat one perceives there still to exist. The danger assessment scale, many of you are probably familiar with that. And that scale, which can be obtained and lots of information about it, including research studies that have been done with it, can be found on, if you just Google danger assessment, Jackie Campbell scale. And the danger assessment scale provides a well-researched actuarial measure of level of risk. So not only can one use the perceived threat scale, but one can look at, based on research, what are factors that have been used to reduce danger, and then get some sense of that. Going back a bit. Well, where did we go here?
I think the slides are a few ahead. You need to go back.
Yeah, okay, thank you. So an additional measure that is can be quite useful is the Stressful Life Events Screening Questionnaire, which is a measure that assesses other types of trauma in one's life, not just partner violence, but other types of trauma. And this can be quite useful in helping to understand a survivor's response to partner violence in the context of more chronic trauma, and is particularly helpful in explaining one's vulnerability, perhaps, or just the chronic impact of multiple types of trauma on the individual. The effects of traumatic exposure, there are two measures listed here that focus on two quite common effects of partner violence and trauma exposure more generally. The post-traumatic stress disorders checklist, it's the DSM-5 version, and although one is not intending here to make a diagnosis, that's not the point of this, it's really to help identify specific problems that the individual may be experiencing because of exposure to trauma that are more easily, or that can be discussed and identified beyond asking the survivor, how do you think this has affected you? It helps, again, just like with the partner violence behaviors, this helps with another way of looking at and articulating some of those effects. And then finally, the last one, the patient health questionnaire, is a very commonly used 9-item set of questions that look at depressive symptoms. This one's used in primary care very commonly. So these are tools that can be quite useful in getting at additional information, and let me just emphasize that they're not for the purpose of scoring, get a score, and reporting a score of some sort. They're really for the purpose of filling out the detail and, in some cases, creating yet another story or narrative based on something that has been identified within these more structured ways of getting the information.
That's great. This is Leslie again. And I just want to pick up on that point, and that is that a lot of times those of us want to try, we think we might, some people call us and they say, isn't it better if I'm doing a case to have a diagnosis of post-traumatic stress, etc. And the answer actually is, and I've seen this from years of training the adjudicators at the Department of Homeland Security that decide these cases, they'll tell you is they would greatly prefer, their favorite form of evidence, separate from their number one favorite form of evidence is the victim's affidavit. Their second favorite form of evidence is an affidavit from a service provider that is working with the victim, that has an ongoing relationship with them. And that second affidavit, the affidavit from an advocate or a therapist or something like that, what they're looking for in that affidavit is not whether the person has PTSD or some other diagnosis. That's not what they care about. What they care about is the story and the credibility of the story. And so the details of the information that may or may not someday lead to a diagnosis provides really good information for assessing the victim's credibility and for assessing the level of harm the victim has suffered. And that's why we're providing these questions derived from these, but not to be used in a diagnosis purpose, and it doesn't help your case necessarily to go that way. And Edna and Mercedes can talk more about that when they're speaking. So let's move on. I mean, essentially, so what you'll do is once you get the affidavit, as I said, you edit it together, you clarify timelines, you get it in a cohesive whole, and then you work with the client. You have the client at the end read it back with a whole narrative of the whole story and how it affected her, and that provides you an opportunity to clarify and correct issues as it comes up, but it also provides her an opportunity to have that additional exposure to the story that is going to help her heal at the same time. So can you, for those of you that have helped an advocate write their story, can you raise your hands? I'm going to push the button next to the name on the top and raise your hands if you've actually worked with an advocate who's filed a story. How many of you, let's do it this way, how many of you advocates who have helped a client file their own immigration case? Why don't you raise your hands if that's true?
Okay,
Advocates
so Leslie,
you may need to clear it.
So Leslie, I see we have about 38 people, 38 out of 210. So I'll lower everyone's hands and we can do the next question.
Are you an advocate who's worked with an immigration lawyer who was helping file the case? David, you can go ahead and check if you'd like. I guess I can.
Great, and so what we're seeing is it's a little bit, no, people are still doing, Leslie. We've got more people that have worked with an immigration attorney, so it's about 43 out of 211.
Great.
I'll lower the hands now.
Okay, and how many of you are immigration lawyers who've worked with their client to do a story themselves?
Okay, so our immigration attorneys, people are going ahead, and we are at about 20.
Okay. And how many, are any of you lawyers who are not immigration specialists who have helped victims write their stories for VAWA or U visa cases?
Okay, and I have to lower the hands, so can you say that again for people, Leslie?
Advocates, lawyers who are not immigration lawyers, but have helped
so how many?
Work on affidavits.
Okay, great. And so we've got about 15, 16 of those have done this, so we've got it there. I'm going to lower the hands. Now what about therapists or mental health specialists?
That have worked on affidavits.
Okay, and now we can see that these are all getting kind of similar numbers. There's about 14 people who said yes for that. And now let's see who we missed.
Okay, so let me ask one other question. How many of you are immigration lawyers who routinely work with advocates or therapists in helping develop the victim's story?
Okay. So we're getting how many attorneys have worked with an advocate or a therapist or a mental health specialist, and what we see, Leslie, is about 10 people.
Okay, great. So what's good is that you're seeing by these questions there are a variety of different ways to do this, and our goal, and that's why I love this picture so much, is to have all of you get involved wherever you're sitting, whether you're an advocate or an attorney, a therapist. There are ways to get involved in helping the victim, and there are no right answers for each victim. You know, every victim is going to be different about who's going to be the best person to work with her to do their story. We want you to think about your professional title shouldn't limit whether or not you can play this role. I'm going to turn it over to Edna.
Thanks, Leslie. So I'm going to talk a little bit about how the structured interview questionnaire worked for new clients. In general, I think that it's a great tool for anyone starting out doing immigration work and working with survivors of sexual assault, family violence, or human trafficking, because it lays out all the legal requirements that are needed when you're filing the actual application when working on a story with the individual, with your client. It's also really useful for experienced attorneys because I think people who have a little more experience doing this work tend to do it in a certain way, the way they've been taught all along, and it might not be the most effective way. And so when I use this, I have about 10 years of experience working on immigration cases, and when I actually saw the questionnaire, my first thought was, that is a lot of pages, and it's going to be a lot of work. And it is a lot of work in the front end, but I think overall it made the experience much better for the clients that I was working with. It allowed me to have the clients write the story in their own voice, and I think that voice came out in a much clearer way than perhaps the way that I was doing it before. It also helped to build some trust in the beginning, especially at the very inception of the interview, when I asked them about their story or what happened, how they met their spouse, or how things progressed in their relationships, or about a really traumatic, violent sexual assault or a trafficking situation, and allowing that individual to speak uninterrupted, which I don't think happens very often when you're working on immigration cases, was really gratifying for a number of the survivors that I worked with. They felt like they had a voice, and they felt like I was there to listen to them from the beginning, and it made them more willing in the end to provide other information to me as we progressed in doing the rest of the casework. I will say I know there have been a couple of questions about cross-cultural interviews or limited English proficiency with some of the clients, and so we do get clients that are Spanish speakers, and I speak Spanish, and so we were able to do those interviews in Spanish, but I also work with a number of advocates for other clients who are limited English proficient, and I don't speak their language. And I think that that's also the value of this tool, is that you may be working with a client where there is a language barrier, there may be a cultural barrier, they're working with an advocate they already trust, and it's laid out in a way that an advocate can know what information you need for the application, but also use it in order to give the survivor that they're working with a voice as well too. And so having the survivor work off of that existing relationship, and then you using that relationship with the advocate that you're already working with, is really fulfilling and great as well too. And so I think that the tool itself is real helpful with those new clients. I believe Mercedes is actually going to talk about existing clients and how it can help with existing clients who may be having difficulty just telling their story in general. So Mercedes, I'm going to turn it over to you.
Thank you, Edna. Yes, I used the tool with existing clients, and I had the same concerns that Edna had with the time that it was going to take to use this tool, because it is a long tool. However, I found that the clients that I used it with were clients that had difficulty disclosing some of the abuse, and oftentimes they didn't understand, or they didn't think that that DHS needed such sensitive information, or that immigration needed such sensitive information or details for their immigration process or for immigration relief. So I use the tool with those clients. I'll talk about one particular experience that I had. I'll use her as an example. She was a client that was very evasive, but mostly not because she did not want to tell us her story, but because she was embarrassed by things that had happened to her. And I went with my instinct when I filed this application. I knew that we didn't have enough from her original affidavit that she submitted. It was about a page long, and I did have a letter from her therapist. However, I decided to go ahead and file it, and we'll talk about the reasons why in the next slide. But I waited for a request for further evidence, because that way I had something that demonstrated to the client why I needed more information. And I did receive that request for further evidence, which we call the RFE, and I decided to use the tool with her. The tool was very effective with her because she opened up to the questions that I was asking her. She actually disclosed much more than we even thought or imagined that had occurred in her relationship. So that was very helpful. We sat down for an interview of about 3 hours, and during the 3 hours, we took some breaks so that we could work on some of the questions so that she can recover from some of the questions, because we're asking for very sensitive information. We also, one of the things also, and I'll go into the next slide, is many times the client, we need time to build trust with our client. And I think that in using the tool, in first submitting the application, I gave us an opportunity to get to know her a little bit better, to have more of a relationship with her, so that by the time that we received the request for evidence, we were able to sit down with her for a period of 3 hours and go through these questions and receive more information to help her and write a more effective affidavit that was more, that provided all the information that immigration needed. Let's see, what is the value of filing early and why I decided to file early in this application? Well, I didn't want to wait until we established that relationship so that we could have a more effective affidavit. I decided to go ahead and file it with a short affidavit because she needed a driver's license. She needed to obtain a receipt so that she could get an ID. And so I decided that in this case, it was more helpful for me to file early and wait for a request for evidence. And benefits for victims of filing early are, one, protection from deportation. If she's in removal proceedings, we can definitely file the application and then file the copies of the receipts with the immigration court in order to stay the removal proceedings. She may have earlier access to work authorizations. In this case, my client was filing a VAWA application concurrently with an adjustment application. And so that's why we decided to file early without the affidavit. And in some states, she may be eligible for benefits. And so these are the reasons why we may think of filing early. Also, if she's involved in a family law case, they may take that into consideration if she has a work authorization.
Mercedes, this is Leslie. I just want to add one other thing.
Sure.
There's a special computer system. You don't have to switch it, David. I'm just going to say one sentence. There's a special computer system at DHS so that if you file early, if you file first, the case gets entered into a computerized system at DHS that is a VAWA confidentiality system that protects the client from deportation. So even if you don't have a deportation case, if you're concerned that when you serve him with the family law papers, or if you go to get a protection order and you serve him with service, that he might call DHS to have her deported, filing early helps keep her out of deportation or helps them from reacting to calls he may make to turn her in.
Thank you, Leslie. And also these are strategies that we use, and they're dependent on the client's circumstances, and we take all of those factors into consideration when filing, whether we file early or not. Okay. Okay. And I'm going to turn this over. Well, this is, okay. I'm sorry. Also, how did this structured interview questionnaire work? In my second example, in using the tool with my clients, I decided to let my paralegal use it with the client because she had a better relationship with her. She had already established that longer-term relationship. The trust was there. And so we made the decision that it would be better if she would do the interview. And so sometimes we have to make that decision. Sometimes it's not always the attorney that's going to use it. It may be the advocate. It may be the paralegal, your assistant. One of the things that I did also was I gave a copy of the questionnaire to the therapists that are located at our one-stop domestic violence center. I'll add my office is located within a one-stop domestic violence center, and so we work very closely with the therapist, and we'll talk about that a little bit further down in the presentation. But in my case, I decided to give it to the therapist so that they knew what we were looking for when working with the clients that we were referred to our program. One of the other benefits of using the questionnaire, and again going back to the fact that they didn't feel that all of this information was necessary for immigration, was that now they saw a pattern to the questions. They saw this is an interview that is being used with other clients, with other persons with the same type of applications that they had, and they were seeing a structured interview that we were using. And so they were more likely, the clients that we used it with were more likely to respond to those questions more openly, because now they saw that these were necessary, these answers were necessary to build on the affidavit that we were going to be submitting to immigration. Also, one of the things that we found was that the questionnaire helped to identify things that we didn't see maybe in our initial intake, or that they would not otherwise tell us if we didn't establish that relationship, that deeper relationship, to ask deeper questions and more personal questions. Okay, Leslie, I think I'm going to turn it over to you.
Actually, Marianne.
Oh, Marianne. Okay.
So now let's just talk a bit about what it takes to do this. And so I'll talk about what it takes from the advocate or the attorney to work with the client in this way from the perspective of a trauma perspective. So the first set of things that it takes is to being able to do this kind of work with the client in a way that provides warmth and empathy and connection. And so in some respects, I'm sure I'm speaking to the choir because you do this work. I suspect all of you know this already. It's the case that working with trauma, whether it's immigration trauma or related trauma or anything else, requires a holding of a space that really allows the survivor to have their experience and tell their story in a safe place. And so the warmth, empathy, connection, non-judgment, all are important because they essentially help to create safety. Now, sometimes that's not enough. Sometimes other things are necessary, simply logistical things, which is to ensure that the physical space is safe, or that is perceived to be safe, that the door isn't going to just swing open with anybody walking in the middle of the story, for example. So providing a space like this requires something different from the advocate or the attorney or the therapist, for that matter, in terms of our personal resources. We can't just do this in a fact-finding way. The second sort of thing that it requires to do this work from a trauma perspective is it not only just being warm and empathic and connecting and not judging, but to actively validate how hard this is to remember and to say out loud in some respects, or even to write on paper what happened. And so validating by way of saying, this makes sense that it would be so hard to remember this, or it makes sense that. And you don't need to go into a big story about why it makes sense, just validating that it makes all the sense in the world that this would be hard, or that the story that you're hearing or reading would be hard to have experienced. And then the final point here is the advocate or the attorney really is required to create this balance, because at the one hand, we're asking survivors to open up a story and to share what happened. Now, we're not asking, and this is not the appropriate place, to open up all of the emotions, that is to work with the emotions, but one can't open up the story without emotions coming along. So even though the intent is not to have the client get all deep into their emotional experience, it will just happen to some extent. Now, there's some ways to kind of help a survivor tell the story without getting so deep into the emotion of it. We'll talk a little bit about that later. But we have to balance this opening up with regulating these emotions, because the point is not to just get someone in there and flood them with emotion, of course. And so just recognizing that that balance may require adjusting based on pacing, timing, the tone of voice, taking breaks, just so that there's a good regulation of the process. And sometimes the process can get kind of out of hand and out of control, and it can go somewhere where one hadn't expected it to go, and we'll talk again about that in a bit. But that balancing is important to keep in mind.
Great. So what I would like to do now is, can I have somebody advance the slide, please? Marianne?
Oh, yes.
Somebody, you have control. There we go. Thank you. Oops. One back, please. Okay. Oops.
Well, no, one more. There we go. Oh, somebody else seems to be doing this too.
I don't have any idea, but if I can have the slide before who was ever doing it.
There you go.
Thank you.
Well, we just needed to go one click.
There, stop. Okay.
Right.
What I'd like to do right now is have Edna and Mercedes discuss from the perspective of an immigration lawyer what their experience is, what advantages they've seen in their practice and in testing this tool that they've seen as an immigration lawyer in collaborating with advocates regarding story writing. Edna, do you want to start?
Sure. I would say when we work with advocates in the field, it's usually with individuals who are in more rural areas, and we have found, particularly because of distance, where we are in Texas. But I think that it's been a real advantage for us because advocates have easier access to the clients that we're working with. They see them every day. They assist them with their other needs besides their immigration case, and so there's already a trust relationship built. And in those particular cases, they may see me only once every couple of weeks in order to talk about their immigration case. In the Austin area where my organization is based, we also work with other advocates in different types of programs like Asian Family Support Services of Austin. We also work with Refugee Services of Texas for our trafficking victims, Safe Place, which is a large domestic violence shelter here. And working with advocates in those situations has been really great in terms of providing other services. Now that we actually have this structured interview tool, I think I'm going to use it more with those advocates to discuss who's appropriate to do the story writing with the applicant, with the client. Who has a more comfortable relationship with the client, and where to kind of start with that. But there are a lot of advantages because you can also divide up work, and I think Mercedes can also talk to this as well. I mean, as attorneys, we're not really. I myself don't feel really equipped to help someone who might be in crisis or going through something that, while I have empathy for, I can't actually really understand or provide help that might be as useful as someone who is more trained to do that. So,
Mercedes?
Yes, I think that there are advantages in working and collaborating with the advocates and therapists on the story writing because The advocates see the clients when they're in crisis. We don't. We see them a long time after that, sometimes a long time after that. And so if we're working with advocates and they know and they have the tools that we need and they know what we're going to be looking for, then it's easier for them to write the story. Or even if we see the client and then they're working with their advocate to write the story, the advocate knows what the client went through. Oftentimes, the client will forget certain details. And this way, they know what questions to ask, and I think it's very helpful. I always find that it's helpful to work together because, as Edna said, we're not experienced. We're immigration attorneys, and there are certain things that we're not aware of and that we don't know, just as there are certain things that advocates are not aware of that we need and that we need to do. So I think that it's very important that we work in collaboration. I always that's what I highly recommend, that we work in collaboration, because we're all working towards the same goal, to help the survivor become self-sufficient and to get what she needs.
And can I just mention one thing, because I know that there was a comment put up by one of the attendees about perhaps not putting the whole story down, and this might be a way where an advocate is valuable. And I know that there are concerns about different types of family law cases, perhaps custody cases, or criminal cases in which applications can be subpoenaed or affidavits can be subpoenaed. And I think Leslie can talk a little bit more about this. But some of those applications can't be subpoenaed, at least from what we do as an attorney, because of work product and privilege. And there are other things that apply with advocates. And so you can divide up some of that to allow a survivor to actually tell their whole story. You might not use it for their whole immigration case, but you might get aspects of their story that you need out. It will still help with the healing, and then you can edit the affidavit to what you need, or the story to what you need to actually submit to immigration.
Right, and what Edna was referring to, this is Leslie, is under VAWA confidentiality laws, which were strengthened in the passage of the Violence Against Women Act of 2013, courts should not be turning over, and as part of, they shouldn't be seeking, the perpetrators shouldn't be able to be successful in family court in getting affidavits, copies of these from the immigration case. If they subpoena DHS will deny it, and federal courts have upheld those denials. And we've worked with attorneys, family law attorneys across the country, providing them sample briefs to use, and almost all of them have been successful that we've worked with in getting the family court judge to decide not to allow discovery of the affidavit because it would be violating federal VAWA confidentiality laws as part of the family court case. So I think that the risk needs to be assessed to the victim, but the benefits of getting a quick approval and in a VAWA self-petition or a U visa case that can come from getting in the information, and the healing benefits can outweigh the any risk there is in family court. And I put up in the chat our telephone number for technical assistance, and maybe Rocio, you can put the telephone and email again. But we're available, and we do technical assistance both directly to judges and to lawyers in family court case around these discovery issues.
Leslie, and if I can also add that the structured interview is broken down into different sections. And so you may not get, if you're working on a U visa case, you can use the U visa portion and ask only those questions that are necessary for the U visa application. And you don't have to ask questions that you may not need, or, obtain information that you may not need, such as in a VAWA case. So that's the structured interview is helpful in that manner, that it is broken down into the different types of applications that we would be applying for.
Great. Mercedes, can you put the next slide on, and then we're going to Marianne.
Sure.
Okay. This is just a brief comment on why the interview might be helpful from a trauma-informed perspective. The first point, questions reflect the survivor's experience. I think here it's really the the fact that for some survivors, in hearing these questions, they can see that they actually reflect some or all or most, although not necessarily every single question, what they've actually gone through. And so I think there can be some sense of validation of hearing someone ask you a specific question about an experience you've actually had. It's kind of related to the other point here, which is, actually it relates to the last one, which is in this way it signals that the attorney or the advocate actually gets it. They know the kind of thing they may have experienced by asking the right questions. It's just when we go to the doctor, if they ask certain questions, we realize they get it. They know what they're talking about. And so it's the same kind of thing here. It puts less of a burden in some respects on the survivor to have to come up with all of it as if this is just about her. And then so to the middle point, sometimes hearing these questions is a relief, because if a survivor knows these are not questions that were designed just for her, these are questions that are asked more broadly of other individuals who are applying for this similar relief, then it becomes, there's just a bit of a distance between, yes, I experienced that, and there creates some sense that this is what others who've gone through what I've gone through might also experience. So I've seen this a lot in the evaluations that I do, not necessarily all with immigration cases, but there's some sense of, wow, you really get what this is about, and some sense of relief again, because it's not just about them as an individual person, it's about a broader experience of people who've had this same kind of thing happen. Moving on, we talked about validation. I cannot underscore enough how important this is. Just relentless validation. I mean, not to the point of absurdity, but one can't validate really enough. And relentless empathy. Not sympathy and not gushiness, but just recognizing that this is difficult, this is hard, this is something that that the advocate attorney sees. And the comment before, I think, about, the attorneys don't necessarily know how to do this empathy. I think at whatever point anyone interfaces with the survivor, be it for the structured interview or simply other pieces of the process, that the empathy and the validation in the form of a manner of interacting become essential. But I think everybody probably already knows that. I think, Mercedes, it was you who commented that the interview is broken down into sections. I think it is very important to monitor the process, take breaks, and to allow the survivor in some ways just to metabolize the process as one's going through it, so that one's not flooded.
Yes, definitely.
Which is really just the last point, which is to pace the work. It doesn't always have to be done in absolutely one setting, marathon setting, and so to pace it in a way that works for the survivor and for the advocate attorney, by the way. So that brings us to the point about what happens when. What happens when the client becomes overwhelmed, goes into crisis, tells you about suicidal thinking. We have, as Leslie talked about, are in the process of developing a video to illustrate some of these particular issues. And so the scenarios in that video really reflect, for example, a traumatized client who has multiple traumas and who becomes overwhelmed by telling all of them and talking about, in some cases, illustrating, demonstrating some grounding techniques, some ways at which to create some sense of distance between the story and what I'm experiencing right now, so as to create a bit more of an emotional buffer It's not, again, about immersing oneself in the experience. It's simply about getting it out. And so anything that can create a sense of, I'm telling you this story, I'm not reliving it, can be helpful. Some clients become very anxious and even have difficulty breathing, and so simply pausing, again, grounding, creating a sense of just relaxing, maybe standing up, taking a deep breath. Those kinds of calming, relaxing just strategies might be necessary to help that kind of client. Kind of on the opposite end, a client who's so shut down that it's even difficult to speak or talk about any of it, starting with simply reflecting that reality, reflecting, validating that this is really hard to talk about, can help because it starts where the client is, which is kind of a cardinal rule. One can never go where a client isn't, and one has to just start with whatever the client's experiencing in front of them in being able to tell the story. And in that kind of situation where the client's having really trouble talking about the story, let's slice it thinner. So let's just talk about this one piece. Or let's just for now talk about, and then pick something that is either a little bit easier to talk about or a piece of something so that it's digestible, it's manageable, it's not so overwhelming. One can notice body language and comment on it. I can see that you're really holding this all in as you're noticing a client, perhaps just with her arms or her body holding herself. But you're really, again, not trying to just break this whole process open, but helping her open up just enough to begin letting out the story. With a client who is tells you about or makes some comment with regard to suicidality, and this does come up from time to time, it's important to directly assess whether the client has actually thought about hurting herself, thought about killing herself. Does she have a plan for doing this? Does she have the means to do it? So that one can get a sense of how serious is this suicidality. Now, I realize that advocates or attorneys, neither one, are mental health professionals, and that's true. But once a client makes reference to something regarding hurting or killing oneself, or it's just simply not worth it, that sort of thing, it does become important to assess what is she really saying to you. You may be the only person to whom she's willing to even show a hint of her struggle with this. And although you wouldn't be the person to manage it entirely, you might be the person to help her say out loud, yes, I have thought of it, I do have a plan. And with time, one would then need to connect to resources so that we don't send clients out on the street because nobody really ever bothered to ask. Asking doesn't make suicidal intention worse.
Nicole? Oh, you're here? Okay, I'm going to do this now.
Somebody seems to have their phone still not on mute.
All guests have been muted. You can unmute your line by pressing *6.
Hello, this is Chance Sniffen. If the presenters only could unmute themselves, please do so. No one else needs to do anything.
Marianne?
Okay, here I am, I think not muted again.
Yes.
I finished with this. Again, the thing Leslie said before, the videotape will be available soon. Techniques for soothing. I often think of the term soft, slow, and low. Simply shifting one's voice a little softer, a little slower, a little lower. And the voice almost moves in, creates a kind of softness that can be very useful. It's just sort of what we do naturally in our human interactions, but it's one way of thinking about it. Grounding someone who has gotten overwhelmed or very distraught about the trauma really refers to just bringing the person's attention back to the present moment. Suspending the interview for a moment or for that day if necessary, but doing whatever it takes to get the person to focus on the fact that they're not sitting in this chair, they're in the office with you, we're looking out the window, it's snowing outside, actually it's raining outside as I look out my window. I can feel my feet on the floor. Let's stand up, take a breath. It's bringing the person's attention, grounding them back in the present moment, because where they are is back there with the trauma and the feelings. And so that just becomes a good basic tool to have in everybody's pocket. Okay, Leslie, I think you're up next.
So Marianne, let's talk together about kind of coercive control. One of the things that we also are built into this tool is how to identify a pattern of coercive control in a relationship. And this part of the tool will be helpful in any of the VAWA or U-Visa domestic violence cases, but it also could be helpful to family lawyers and in other situations where understanding the dynamics of domestic violence and coercive control, as in battering or extreme cruelty, could be useful. So it might be cases of people filing for work authorization who are spouses of people here on work visas, or it might be cases of people applying for certain public benefits that are available to people that are battered or subject to extreme cruelty, even if they don't have, even if the perpetrator isn't their spouse or partner. And there's limited cases where that's true. And so, and the questionnaire helps you identify those patterns. Marianne, could you very briefly just kind of outline what we mean by coercive control?
Yes. I think we all know kind of what coercion is. It's kind of like I know it if I see it. But it's useful to sort of be able to have a map of understanding it that can be articulated to the court, as you said, in any different kinds of cases. So there's the model of coercive control that several of us, including you, Leslie, Lisa Goodman, and a number of others worked on through an NIJ grant, has these components. So what are they? Well, in order to engage in coercive control, there has to be some form of setting the stage. There has to be some foundation on which a coercive tactic actually can take hold. Otherwise, it's just discounted. It's not viewed as very credible, and so forth. So what are some of those setting the stages? Well, having histories of abuse create certain vulnerabilities, and that lays pretty fertile ground for coercion. Having vulnerabilities in the victim, quote unquote, of coercive control exploited, so that if someone has a prior trauma history, a childhood abuse or sexual assault history, or any kind of maltreatment in childhood or any other time, there's certain vulnerabilities that get created. And so either using that information or even inadvertently exploiting that sense of vulnerability can create this setting the stage. Wearing down resistance. Some abusers seemingly quite intentionally wear down resistance by sleep deprivation, food deprivation, isolation, all very good ways of wearing down resistance. And they work to soften, if you will, the victim to the effects of coercion. Kind of on the opposite end, facilitating and kind of over-attachment, the sense of, I'm the only person in the whole world who could possibly ever love you because you're so damaged, or because you're so this or that. Or somehow, I'm the only one who really understands you. Facilitating a sense that this person is in some way indispensable for their sometimes varied life. So once that stage is kind of set, and in doing almost any kind of history with any given person, it's pretty easy to identify what some of these vulnerabilities or the setting of the stage might have been or might be. And then there's the coercive demand. Coercion in our model is basically defined as essentially a contingent threat. That is, if you don't do or not do some certain thing, then some bad thing will happen. And so that demand is not always stated really clearly or even verbally. Sometimes it's just known that I knew I had to be home immediately after work. I knew I had to get up every time the doorbell rang. I knew that I had to answer the phone and never just let it ring because terrible things would happen. Sometimes they're very stated very clearly. So what are those demands? And that's not the essence of coercion, although it's important to know, what domain the demands are in. Are they about her clothing? Are they about her activities? Are they about how she deals with the children? Are they about where she goes and with whom she speaks, and so on? The real essence of coercion is the threat. Or else what? What's going to happen if I do or don't do this thing? What's going to happen if I don't read his or her mind and do or don't do whatever it is I'm expected to do? That's the threat. But it doesn't go very far if there's not some sense of surveillance. That is, people can say threatening things all the time, but if there's not some sense of he or she will know if I do or don't do that, then it doesn't really have much weight. Now, sometimes it's obvious. The person's at home waiting, and if you don't come home, and of course I'll know because you'll either walk in the door or you won't. So the surveillance it's important to know that because it's not always that the abuser is going to actually be there to monitor it. And so people can discount that coercion actually occurs because, well, after all, he's at work. How would he even know if you came home and you told him? Well, sometimes third parties. Sometimes the abuser may say, I'll just know. I'll just know. And for some victims/survivors, they often come to believe that he, in some respects, has this omnipresence, this power to just know, even though, in fact, that's not really the case. And so, in some cases, then the coercion is, in fact, carried out. And, in fact, there really then are threatened consequences for having not done whatever the event or thing was that was demanded in the first place or expected in the first place, which then, of course, feeds back to the vulnerability because having once learned that the abuser could and would engage in the actual threatened consequences, and choking, for example, or strangulation is a great example of this. Once a victim realizes that the abuser could actually go that far to the point that I could start not breathing, then future threats and demands are a whole lot more credible than they might have been prior to that time. So the threat obviously has to be a credible threat, but this helps establish the credibility. So that's what we mean by coercive control, and it's really a way of just parsing out a pattern that we know many survivors live with day in and day out.
Okay, thank you, Marianne. So in conclusion, we have a few minutes left. What I'd like to do is conclude with Edna and Mercedes providing us a little bit of background on, a little bit more discussion on kind of how some practice tips and best practices for the group, and talk about, how you plan to work with your clients after they address traumatic memories.
This is Mercedes. One of the things that I did, I had spoken with the client, and I explained that we were going to conduct a very detailed interview, and I asked her if I could let her therapist know. And so the therapist was available after the interview to see her, and I'm really glad that I did that because she did actually need to see her therapist. She requested to see her after the interview. So I think it's important to plan ahead to know that this is going to take a long time, that you are going to probably uncover information that she probably has not talked about in the past. And so prepare for that. It may be very emotional for her during this interview. Another thing is to plan, not only plan the time, but plan on taking breaks, as Marianne said. It's very important to take breaks, even just a few moments to just let her just breathe and to talk about other things or to have a glass of water, to walk around. That was also very helpful because we are eliciting information that can be very personal, that can be very traumatic, and so we need to be conscious of that we are going to be doing this and that we need to plan ahead for that.
Edna, any other practice points or tips? Edna? She's not muted.
Sorry. The more information that you can give a client, the better. That's what I've found. I agree with all the things that Mercedes has said, and I think that telling the client what the intervention is being used for and using it to describe the case overall is very helpful.
Yes.
So, in conclusion, Chad, can I have the controls back? Leslie? Oh, and I can, okay, great, thank you. So, I just want to say that I wanted to thank everyone for attending. We've now come up on the end of the webinar, and to let you know, to encourage you, to let you know that we're all available here for further technical assistance. If you're working on a case and these issues come up, you can call NewApp. Maybe Rocio can post the phone number again and the email. Edna, Mercedes, Maria Jose from VITA, and Marianne are all partners with us on technical assistance, so if you want to reach out to either any of them for further help, you can call the same number and we can get you in touch with them. Materials, again, are available at the web link. We will be posting the video that Marianne was discussing by April 14th or 15th, and there's lots of materials available in the NewApp web library and tools for all kinds of advocates, attorneys, therapists, and law enforcement, and others that are working with victims. So we hope you will you will take advantage of the resources. And we thank you for attending the webinar. And please, if you have questions, don't hesitate to ask them in the chat, and we will get back to you with answers to particular questions by email, and we can also, again, you can call us or email us for technical assistance and provide you information. Thank you again all for your time and attention in joining us.
And this is Chad Sniffen on behalf of the California Coalition Against Sexual Assault. I want to thank everyone for attending, and we really appreciate our partnership with NIOAP and our ability to work on this series. It's something we're very proud of. And I want to wish all of you a great afternoon. Presenters, please switch over to the presenter line. I will be opening that up. And this concludes the web conference, everyone. Thank you. Have a great day.